some sort of methodology how your lordship will allow it?
No, but you are assuming that the court will go into it.
The point is, my lord, there are 4 high courts which took a view after Rajasthan that B.ed is a valid qualification.
No. Nowhere.
We'll read the judgment.
Nowhere.
Say no. After Rajasthan, 4 high courts took the view that B.ed is a valid qualification. Thus, the NCT circular was in vogue and the state rules were in vogue. So therefore, in that situation, if we have been appointed, the valid date is the date when your lord.
This will have to hurt finally in different batches, not like that. It will have to be state by state. See. Yes, I know that. But I mean, it's all right. This is a jamboree,
There is just. The second point which I want to make is.
Yes. If you want,
Clarified your lordship, never
closure, this is we are thinking aloud, not that we made up our mind.
old ones.
We'll give it a thinking. Limited retrospectivity for those who are already appointed prior to our judgment.
Fair enough. Thank you.
Lordship, that's been decided.
Yes.
Correct.
Now the problem comes today's judgment.
Yes.
If it cannot go, they cannot do.
No. That will. Your main judgment dealt with Rajasthan, where appointments had taken place, where interim orders had been passed. In Rajasthan itself, the advertisement was issued 1 month after NCT. Yes.
Some kind of 50-50.
No, the problem is
Happening here is
it's been decided by high courts.
Here is
Yes.
that only those who are appointed
Yes.
prior to our judgment.
That's correct. But they have had high court judgments.
Been appointed will go.
They went to the high courts. They went to the high courts. The high courts decided against them.
This Madhya Pradesh will go.
Madhya Pradesh, no. Each state has the high courts dealing with these matters.
High Court.
I'm sorry.
Our judgment will come. From our judgment,
Yes.
to that, if anybody has been appointed, he is safe.
No, in Rajasthan,
Has been appointed after our judgment, then they go.
Correct.
it can't happen.
The only thing is,
Malaj, it can't happen because in Rajasthan,
forget whether it
Yes.
happened or not.
Otherwise, you bring another appeal and.
let them do it.
Now the only
High
thing
court
is-
judgment
Yes.
being rendered will not matter to your lordship's clarity.
Yes, my lord.
Yes, it will.
Yes.
My lords, because here appointments, we'll give you a list showing
Mr. Simple, how
appointments are all before that advertisement. Each of these states and the high courts have decided that clearly.
Malaj, I'm sorry to say, you will have to.
argue today.
My lords, just 1 minute. It will go contrary not only to the judgment delivered today, but at least 3 orders or judgments passed to this court.
If it goes contrary, you can always seek a clarification or a change there.
No, it goes contrary to your 3-judge decision. This court's 3-judge decision.
The court.
Just there was a party in the 3 judges.
It does not.
Lords, we have a preliminary. 1 minute. Lords, your lordships will have to hear us.
Malaj,
Your lordships will have to. Wait, before your lordships.
Malaj,
1 minute.
your lordship.
Hear it state by state. Lordships, each state has different facts, your lordships.
We may be committing wrong, but let us.
Your lordship.
Lords, we have a preliminary objection, my lord, to the very maintainability of this IA. That your lordships will decide, my lord, on the application, my lord. Because how is this application for clarification even maintainable?
No, your lordship may issue notice then, because the main judgment is being clarified. Parties have to be heard. Your lordship may issue notice.
Higher reply than your lordships may consider.
This is on the preliminary objection. We have orders which they have taken note of.
This matter can't be decided in this fashion.
Other than if he gets.
Final reply.
You must give note.
It is not retrospective.
What is your?
The ground of curative is natural justice. I'm sorry to say this.
But
If
that-
your lordships are going to clarify it without hearing us, I think it will be a problem. We have.
Your lordship, your lordship should issue notice, Malad. Your lordship should not.
It's pending matters in High Court, your lordships.
This is not fair. The procedure is not right.
We will be there.
But this procedure, this,
11th August.
11th August. ठीक है, 11th August.
Malad, yeah.
Please allow.
Malaj, we'll file a reply.
11th August
Because
2023.
just one thing, please. Then please, my lords, we have to observe one thing. The point is that most of these appointments were made subject to the outcome of this particular
By High Court.
My lord,
High Court.
my lord, all good things must come to an end, my lord. Buck must stop at your lordship's door. Your lordships may decide.
Malad, no, this is not.
Please dictate the order.
11th August 2023.
See the brighter side of it.
No.
Only diplomas after this.
Ah, that's right. And vacancies are.
Then the judgment also.
But what-
Can apply higher secondary.
But how, we get age barred also.
Out of
What is the point of ever having gone to court then?
This court
11,000 posts being taken up by
this
B.ed, I think that's
dismissed a set of appeals.
The lords may issue notice. The lordships may consider this because there is a lot to be said. I don't think it will be appropriate to just decide like.
My lords, nothing would happen, my lords, by a week's time. Let us file our reply, my lord. There are factual averments to be traversed.
Each state is different, your lordships.
This court dismissed a set of appeals against a judgment of the Rajasthan High Court dated 25th November 2021. Stop. The dispute involved in these proceedings were eligibility of B.ed candidates to enter into the teaching stream at the primary level of various states. Stop. The Rajasthan High Court had held that to teach at the primary level, the eligibility criteria would be d.el.ed, which is a diploma course, and not B.ed. Now an application has been taken out by the state of Madhya Pradesh seeking clarification. Seeking clarification, but actually this application is in the nature of a review, and once the said judgment to operate retrospectively, prospectively. Stop. The applicant here is state of Madhya Pradesh. Stop. The aforesaid dispute arose in large number of litigations in various states, and in some states, some state high courts, the matters are pending, whereas in some, it has been decided. Stop. Paragraph. Before us, learned counsel appears for two sets of applicants, one set wanted retention of this judgment, which would result in loss of employment to those who were or who stood already appointed in different states. The other set of applicants submitted that they were they had entered their employment through a legitimate course as per the notification issued by the respective appointing authorities, which did not stipulate d.el.ed to be the only requisite qualification. 1 minute. Subject to the outcome. We will explore.
And the fact that it was under the all B.ed.
Now, in the light of this factual foundation and having considered the fact that the applicants, the B.ed applicants are claiming that they had entered their employment as per the qualification criteria devised by the appointing authority, equity should go in favor of retention of their employment. Stop.